Hi, my name is Zak Goldstein. I'm a criminal defense attorney in Philadelphia with the law firm of Goldstein Mehta LLC. We handle a lot of aggravated assault cases, and so that's the topic that I'm going to talk about today, which is aggravated assault. Now, in general, aggravated assault is always a felony in Pennsylvania in state court, and there are three main types of aggravated assault that a criminal defendant could find themselves dealing with in Philadelphia and throughout Pennsylvania. The first type is the most serious. It's a felony of the first degree. And when aggravated assault is charged as a felony of the first degree, then it typically involves serious bodily injury, meaning the defendant caused, knowingly, intentionally, or recklessly caused or attempted to cause serious bodily injury to another person. Typically, that's going to involve either someone really being injured, or it's going to involve a weapon. So if you shoot somebody, if you stab somebody multiple times, if you punch someone 100 times, if bones are broken, that's usually going to be aggravated assault as a felony of the first degree. Now, the second type is aggravated assault involving law enforcement or other protected classes. It could be a correctional officer, a police officer, a judge, public defender, district attorney, SEPTA employee, or healthcare worker. Those are all members of protected classes for the felony of the second degree aggravated assault statute. In that case, it no longer has to be serious bodily injury. If you try to cause bodily injury or knowingly or intentionally, and it can't be reckless, meaning it can't be an accident, it can't just be flailing around, it's got to really be an attempt or something you meant to do. If you cause bodily injury or attempt to cause bodily injury to someone who's set out in the statute, like a police officer, then that is always a felony in the second degree, even if that person just has some minor bruises or redness or swelling. It doesn't have to be a serious bodily injury. And then the third type of aggravated assault is also a felony of the second degree. That's bodily injury with a deadly weapon. Meaning, say you stab somebody in the arm and they're totally fine. They make a full recovery, they get a stitch or two, it's not a major permanent injury, then that might just be bodily injury with a deadly weapon, because a knife used for the stabbing is a deadly weapon, but it's not serious bodily injury because it's not something that's going to permanently affect their lives. There was no risk that they were going to die. It's aggravated assault as a felony of the second degree. Now, for each of these charges, there are defenses. If you're charged in state court in Pennsylvania, you have the absolute right to a trial with a judge or with a jury. In most cases, you're also going to have a preliminary hearing. And so with some of these, the aggravated assault charges, there are defenses even at the preliminary hearing in terms of the sufficiency of the evidence. With aggravated assault as a felony of the first degree, many times the winner of a fight gets charged with aggravated assault. The complainant will say, "Oh, I got punched, 5 times, 10 times. I got punched a bunch of times in the head," and the prosecution will try to argue that that's aggravated assault as a felony of the first degree. So, in terms of a sufficiency defense, there could be a defense. Well, serious bodily injury was not caused. This person was not really injured. And just punching or throwing some kicks as part of a fight, well, that's not an attempt to cause serious bodily injury. So the charge should be thrown out. It should just be a simple assault, even at a preliminary hearing where there's a relatively lower standard than at a trial. In terms of sufficiency for the other statutes, there could be challenges to what the defendant actually intended to do. With the law enforcement aggravated assault, it can't just be resisting arrest. It can't be flailing around, trying not to be taken into custody. Even if a police officer ends up with some bruising, that has to be the defendant's goal. It had to either be intentional or knowing. It can't just be something that happened because of reckless conduct. So that could be a defense to the aggravated assault as a felony of the second degree charge. And then there's also sufficiency defenses for the bodily injury with a deadly weapon type of aggravated assault, which can be challenging whether or not it was really a deadly weapon. You see a lot of F2 aggravated assaults where the prosecution or the police, they're never really quite sure what kind of weapon was involved. Maybe it was a screwdriver, maybe the defendant was wearing a ring that led to a large cut. A deadly weapon has a very specific definition, which means it's either a firearm, whether loaded or unloaded, It's something that is a weapon, like a knife, or otherwise when it's some sort of random object, if it's a pen, a screwdriver, a plate, something that the defendant just grabbed, then it has to be used in a manner which was calculated to or likely to produce death or serious bodily injury. So if an object is grabbed in the course of the fight, it's not automatically a deadly weapon. There has to be something about the object that makes it particularly deadly, like a knife or a gun, or it has to be the way in which it was used. Sufficiency is always often a potential defense in these types of cases, but there are always the other types of defenses that come with any criminal case. Aggravated assault could be a charge with a shooting, in which case defenses could come down to misidentification. Did the witnesses really point out the right person? There could be credibility defense. So the witness is telling the truth about what they saw. Are they telling the truth about their injuries? Are they telling the truth that the defendant really tried to do this? And then there's other defenses that are really case specific. There could be speedy trial defenses if the defendant isn't brought to trial fast enough. There could be motions to suppress evidence if the defendant is stopped illegally by the police or questioned illegally without Miranda rights or questioned as part of an illegal stop. These are all potential defenses to aggravated assault charges and potential defenses in any case, because there's always the right to a jury. There's the right to a trial with a judge if you choose to go that route. And then there are also these constitutional defenses, such as the right to a speedy trial, the right to be free from an unreasonable search or seizure, and the right to Miranda warnings. Now, we have handled countless aggravated assault cases, countless attempted murder cases, both as trials with judges and with juries. We have won full acquittals in aggravated assault and attempted murder cases. And if you were dealing with any type of assault charge or any type of criminal charge, we can help. Our criminal defense attorneys offer a free 15-minute criminal defense strategy session to each potential client. So call us at 267-225-2545 to discuss your case today.